I was driving through my old neighborhood the other day and I saw it. The sign. That stark red and white foreclosure sign staked into a lawn where the grass had gotten just a little too tall. And I think for most of us, when we see that, or when we think about losing a home, we picture it as this singular tragic event.
Right.
It's a moment in time. You picture the moving truck, the empty windows, maybe the family driving away. It feels like a scene from a movie.
It's very cinematic. We tend to narrativize it as a climax, the end of the story.
Exactly. But we have been reading through this absolute mountain of documents, legal statutes, history books, international comparisons, and what you realize almost immediately is that the event is an illusion. Foreclosure isn't a moment, it is a machine.
It is a machine, and it is a massive industrial-scale machine with very specific gears, levers, and triggers. And the scary part is that this machine is humming along in the background of the housing market every single day, but most people have absolutely no idea how it works until they get their sleeve caught in it.
That is the perfect image, and that's our mission for this deep dive. We aren't just going to talk about the sadness of losing a house. We are going to pop the hood and look at the mechanics of loss. We're going to decode the legal machinery that makes it possible.
And we're going to define a term that, frankly, most homeowners have never heard of, but it is the most important legal right you possess. It's called the equitable right of redemption.
I have to admit, when I first saw equitable right of redemption in the notes, I thought we were pivoting to a theology podcast.
It does sound biblical, doesn't it? But if you don't understand that phrase, you cannot understand foreclosure. Because legally speaking, foreclosure isn't about taking a house. It is about terminating a right.
So we're going to unpack that. We're going to look at how a 30-year mortgage agreement can completely unravel in just 30 days. We're going to look at the weirdly different ways this machine operates, depending on whether you live in Florida or California, or if you happen to live in Spain or China.
And we have a really comprehensive stack of sources today. We're looking at everything from the Uniform Commercial Code to historical lobbying efforts from the 1850s to some really surprising data from the Federal Reserve about what happens to people after they lose their homes.
So I want you, the listener, to do something for me right now. I want you to visualize a stack of paper. Maybe it's in a filing cabinet you haven't opened in 5 years.
Yeah.
Maybe it's in a fireproof box under the bed. It's your mortgage. It's that inch-thick stack of documents you signed until your hand cramped up. And somewhere in the fine print of Section 18, there is a single sentence that has the power to change the trajectory of your life. Imagine you've missed a payment. The clock has started. What happens next?
To understand what happens next, we have to strip away the colloquialisms. We use the word foreclosure all the time. Oh, the bank foreclosed on the Smiths. It sounds like closing something, like closing a door.
Right. It feels final.
In a way, it is. But let's look at the legal definition. Foreclosure is a process where a lender, the mortgagee, attempts to recover the balance of a loan from a borrower, the mortgagor, who has stopped making payments. But here is the technical core of it.
Okay.
It is the act of terminating your equitable right of redemption.
Okay, let's stop and really dig into this equitable right of redemption, because this is the concept that anchors the whole system. Where does it come from?
It comes from English common law, going back centuries, way back. In the old days, courts were divided into courts of law and courts of equity.
Okay, I think I remember this from civics class, law versus equity.
Exactly. Courts of law were very rigid, very black and white. If the contract said pay by Tuesday and you paid on Wednesday, you lost. Done. End of story.
Harsh.
Very harsh. No excuses. But courts of equity were designed to be fair, to look at the nuance, the equities of the situation. And historically, these courts looked at land as something unique.
Different from just money or a cart of grain.
Totally different. It wasn't just a commodity. It was your livelihood, your legacy, your place in the community. So they decided that if a borrower pledged their land as collateral for a loan, they should have a right to redeem that land.
So even if I miss the deadline, the Court of Equity says, hold on, if he can come up with the money, he should get to keep the farm.
That's it in a nutshell. It's a safety valve. The court is saying we prefer the borrower to keep the property if they can make the lender whole. This right exists from the moment you sign the mortgage. It is your right to say, oops, my mistake. Here's the money. Give me my title back.
That sounds great for the borrower.
Yeah.
I mean, that's a huge protection. But I imagine for the bank, that's incredibly annoying.
It's worse than annoying. It's a liability. From the lender's perspective, this right of redemption is a problem. It creates what lawyers call a cloud on title.
A cloud on title. I like that. It's very visual.
It is. Think of it this way. As long as you have the right to show up with the bag of cash and claim the house back, the bank doesn't fully truly own it even after you've defaulted. They can't sell it to a new owner free and clear because there is this lingering possibility, this cloud, that you might redeem it. So who would buy a house under those conditions?
Right. No one. You'd be buying a potential lawsuit.
Yeah.
So the bank is stuck in limbo.
Precisely. So foreclosure is literally the process of foreclosing, shutting out, extinguishing that right. The bank is going to court or going to a trustee to say, we need to kill this person's right to redeem so we can take fee simple title.
Fee simple title, that's the clean version.
That's the holy grail for the lender. Total unencumbered ownership. Once they have fee simple title, the cloud is gone. They can sell the house, evict you, and recoup their cash.
So when we talk about foreclosure, we are technically talking about a lawsuit or a procedure designed to strip you of a right you might not have even known you had.
That is exactly it. Most people think they're losing a house. Legally, they're losing a right.
Okay, so that's the definition. That's the what. But let's talk about the how, because people miss payments all the time. You go on vacation and forget to mail the check.
Okay.
The auto pay glitches. Being a week late doesn't trigger the apocalypse.
No.
What is the actual trigger?
The trigger is hidden in that stack of papers we visualized earlier. In a standard U.S. mortgage, specifically the Fannie Mae Freddie Mac uniform instrument, which is, most of them, it is usually found in sections 16, 17, or 18. It is called the acceleration clause.
The acceleration clause. That sounds like something from a physics textbook.
Or it feels a bit like both when it hits you. It is the moment gravity shifts. Think about it. When you sign a mortgage, you are agreeing to pay over a long timeline.
30 years, usually.
Right, 30 years. You are agreeing to pay, say, $2,000 a month for 360 months.
It's an installment plan. A really, really long one.
But contained in that agreement is a clause that says, if you break a term, usually by defaulting on a payment, the lender has the right to accelerate the debt.
Accelerate it to when?
To now. Immediately. They don't just want the missed payment of $2,000 anymore. They are declaring the entire remaining balance of the loan due and payable instantly.
Whoa. Let's just pause on the math of that. I miss a payment of $2,000. I ignore a couple of letters. Suddenly, the bank isn't asking for the $2,000 plus a $50 late fee. They're asking for the $350,000 principal balance.
Immediately. That is the acceleration. They are collapsing the 30-year timeline into a single day.
That seems, well, practically impossible. If I couldn't pay the $2,000, I definitely don't have $350,000 sitting in my checking account.
And that is the point. It is the ultimate leverage. Once they accelerate the debt, you can't just pay the missed month to make it go away unless they allow you to cure it.
Okay, so talk to me about this cure, because the timeline here is crucial. How long do you have before this acceleration happens?
The machine doesn't just spring this on you overnight, usually. The mortgage contract and federal laws dictate a specific sequence. Typically, after you miss a payment or two, you get a breach letter or a demand letter.
The dreaded letter in the mail.
Yes. And under statutes like the Fair Debt Collection Practices Act, the FDCPA, this letter has to be very specific. It can't just say, you're late. It has to tell you exactly how much you owe to bring the account current. This is your window to cure the default.
To cure it, like the loan is sick.
It's a legal term. To cure means to reverse the default by paying just the back payments and the fees. It puts you back on the 30-year track like nothing happened.
And how long is that window?
Standard residential mortgages usually give you 30 days from the date of that letter to cure.
30 days.
And if you have a commercial loan, maybe for a small business or an apartment building,
Shorter.
often only 10 days.
So you have a 30-year relationship with this bank. You've paid them thousands, maybe hundreds of thousands of dollars in interest. And the dissolution of that entire relationship basically comes down to a 30-day window.
That's the reality. Once that 30-day window expires, if you haven't paid up, the acceleration kicks in fully. The lender stops asking for the missed payment and starts the machinery to take the house. And this is where the road forks.
Right, because I think most people assume there's just one way to foreclose. You go to court, the judge bangs a gavel, and you lose the house. But looking at the sources, that's not true at all. It depends entirely on where you live.
It varies wildly. In the U.S., we basically have 3 different paths or types of foreclosure. And the experience of losing your home, how long it takes, how much it costs, whether you can fight back, is completely different depending on which path your state follows.
So let's start with the one that feels most familiar to what we see on TV, the courtroom path.
Right. This is judicial foreclosure. This is the standard in about half the states. If you live in Florida, New York, Illinois, or Pennsylvania, this is likely your world.
So how does this play out? What does it feel like?
It feels like a lawsuit.
Yeah.
Because it is a lawsuit, pure and simple. The lender files a civil complaint against you. Bank of America v. John Doe.
So I get served papers.
You get served papers, there are pleadings, hearings, motions, discovery. It works just like a lawsuit over a car accident or a contract dispute.
Which means there is a judge involved.
Yeah.
An actual person.
Yes. And that is the key feature. A judge has to review the evidence and sign the order. If the lender wins, the judge orders the property to be sold under court supervision, usually a sheriff's sale.
Now, looking at this, the pro side seems to be that there is oversight. A human being in a robe is actually looking at the paperwork to make sure the bank didn't mess up.
Theoretically, yes. It offers the most protection for the borrower. You can raise defenses, you can file motions to delay, you can demand the bank produce the original note. You have your day in court, so to speak.
But the con, from the system's perspective, is that it is incredibly slow.
Oh, incredibly. In states like New York or New Jersey, a judicial foreclosure can take years. I'm talking 3, 4, 5 years from the first missed payment to the actual eviction.
5 years?
Yes, it clogs up the courts. During the height of the housing crisis in 2009, judicial foreclosure states were backed up so badly they had to bring judges out of retirement just to sign foreclosure orders. They were called rocket dockets, just trying to clear the backlog.
So the banks and the lobbyists probably didn't love that system.
They hated it. It's expensive, it's time-consuming, and it locks up their capital for years.
Yeah.
Which brings us to the second path, the path the banks built for themselves.
The fast track.
Exactly. This is non-judicial foreclosure, or technically foreclosure by power of sale.
Yeah.
This is common in states like California, Texas, Washington, and Georgia.
And the difference here is no judge.
No judge, no lawsuit, no court pleadings, no guy in a robe banging a gavel.
How is that even legal? Can they just take your house without going to court?
They can, because you agreed to it. If you look at your paperwork in California, you likely didn't sign a document called a mortgage. You signed a document called a deed of trust.
I've heard those terms used interchangeably. What's the difference?
It's a huge difference. A mortgage involves two parties, you and the bank, the mortgagor and the mortgagee. A deed of trust involves three parties, you, the bank, and a trustee.
Who is the trustee, a neutral third party?
Well, neutral is a strong word. It's usually a title company or a subsidiary of the bank. But legally, they hold the power of sale.
The power of sale.
Right. Inside that deed of trust, there is a clause where you basically said, I grant the trustee the power to sell this property if I default without needing a court order.
So you waive your right to a trial before you even bought the house?
Essentially, yes. The process is entirely administrative. The trustee records a notice of default, an NOD, at the county recorder's office. They mail you a copy. You get a statutory period, usually 90 days in California, to cure.
And if you don't cure in those 90 days?
Then they record a notice of trustee sale, publish it in a local newspaper of general circulation, you know, one of those tiny ones no one reads, and 21 days later, they auction your house on the courthouse steps.
That sounds infinitely faster.
It is. In Texas, a foreclosure can theoretically be completed in as little as 41 days.
41 days versus 4 years.
Exactly. Compare that to the 4 years in New York. And it's much cheaper for the bank. What's fascinating to me is the history here. The financial industry has been lobbying for this power of sale system since the mid-19th century.
The 1850s.
Way back.
Yeah.
And their argument was essentially, if we make foreclosure faster and cheaper, we can offer loans at lower interest rates because our risk is lower. That's the economic argument.
Which makes some sense.
It does. But they also used a psychological argument. They argued that non-judicial foreclosure is kinder.
Kinder. How is bypassing the judge and speeding up the eviction kinder?
They argued it avoids the trauma and public shame of being sued. It avoids the in terrorem effects of a lawsuit. They said, look, we're just going to handle this quietly. No bailiffs, no subpoenas, just a quiet sale.
We're just going to take your house politely without dragging you through the mud.
That's the pitch. It's a real point of debate whether that's actually kinder or just faster and cheaper for the bank.
I think I know which side I'd fall on.
Most people do.
Now, there is a third path mentioned in the notes. It's called strict foreclosure. This sounds like something from a Dickens novel.
It is very old school. It's a minor method now, mostly seen in parts of Connecticut, New Hampshire, and Vermont.
How does this one work? Is there a court?
It starts in court, like a judicial foreclosure. But if the lender wins, there is no auction. The court simply orders the borrower to pay the full debt by a set date. They call it the law day.
And if they don't, if they can't make the law day payment,
The title reverts directly to the lender.
no sale, no bidding, no chance of getting any equity back.
No sale. The bank just takes the house. Snap. It's theirs. This is usually only allowed when the property is underwater, meaning the debt is higher than the house is worth.
Why does that matter?
Because if the debt is $400,000 and the house is worth $300,000, a sale wouldn't generate any extra money for the borrower anyway. So the court says, let's skip the charade of an auction and just hand over the keys.
Wow. It's efficient, I'll give it that.
Mm.
But it feels harsh.
It was actually the original method of foreclosure historically. In the medieval period, if you didn't pay, the lender just kept the land. We've evolved away from it because we generally want to see if a sale can generate some suppressed cash for the borrower. But in those New England states, the tradition persists.
Okay, so those are the paths. You're either in a lawsuit, you're on the fast track with a trustee, or you're in New England getting strictly foreclosed. But let's say I'm the borrower. I'm on the tracks. The train is coming. Do I have any way to stop it? Can I fight back?
You can, but it is much, much harder than people think.
Mm-hmm.
We need to talk about the defenses, and honestly, we need to talk about the defenses that aren't really defenses.
Let's start with the big one, the Constitution, due process. If I'm in California and a bank is taking my house without a judge, without a hearing, isn't that a violation of my constitutional right to due process?
That is the most common argument borrowers try to make when they first talk to a lawyer. They can't do this. I have rights. And in non-judicial states, that argument almost always fails.
Why? It seems so obvious.
Because of something called the state action doctrine. The Constitution, specifically the 14th Amendment, protects you from the government. It protects you from state action. It says the state cannot deprive you of property without due process. But in a non-judicial foreclosure, who is taking your house?
The bank or the trustee.
Exactly. Private actors. Private companies. The courts have ruled repeatedly that just because the state allows non-judicial foreclosure laws to exist, or just because the county recorder stamps the deed, that doesn't make it state action.
So, because it's a private contract between me and the bank, the Constitution sets this one out.
Essentially, yes. In California, the courts have even called the due process defense frivolous. They say if you wanted the protection of a judge, you should have found an ender who used judicial foreclosure.
Which is impossible because they all use deeds of trust.
Exactly. It's a theoretical choice, not a practical one. You want the loan. You sign the deed.
Okay, so the constitutional argument is a dead end. What about this tender trap I saw in the notes? Honestly, this seems maddening.
This is a procedural hurdle that stops many lawsuits before they even start. In states like California, Georgia, and Texas, if you want to sue for wrongful foreclosure, let's say the bank actually screwed up, they didn't send the notice, they got the math wrong, you have to first offer valid tender.
Define tender for me.
You have to prove you have the money to pay off the entire debt.
Wait, to sue them for foreclosing on me incorrectly, I have to prove I can pay off the whole loan first.
Yes. The legal principle is he who seeks equity must first do equity. The court says, look, even if the bank made a mistake, if you don't have the money to pay them back, the result would be the same anyway. You'd still lose the house. So we aren't going to waste the court's time.
That's a total catch-22. If I had the cash to pay off the house, I wouldn't be in foreclosure.
It is the ultimate paradox. Legal textbooks explicitly critique this. They call it a paradox because it effectively bars the people who need protection the most, those who are broke from challenging illegal foreclosures. It means only rich people can sue for wrongful foreclosure.
The notes mention a specific case that really highlights how rigid this is. Nguyen v. Calhoun. Tell us that story.
This is a heartbreaker. It happened in California. A borrower, Nguyen, was in default. The foreclosure sale was scheduled for a Friday. Nguyen managed to scrape the money together to cure the default.
Okay, so he's trying to do the right thing. He's got the money.
He got a cashier's check. He put it in a FedEx envelope addressed to the lender. He sent it on Thursday.
Cutting it close.
Very close. The check arrived at the lender's office on Monday morning.
But the sale was Friday.
Exactly. The house was sold at auction on Friday. Nguyen sued, arguing, I sent the money, I tendered the payment. The court looked at it and said, essentially, close only counts in horseshoes. They held that the tender attempt was inadequate because it wasn't received before the sale.
3 days. A weekend. He did everything he could.
A weekend. And the house was gone. The machinery has no mercy for logistics. If the gear turns and your hand is still in there, it crushes you.
That is brutal. It's not just about having the money. It's about the precise logistics of the transfer down to the minute.
Absolutely.
Okay, so legitimate defenses are hard. But what about the wild stuff? I feel like I've read internet rumors about people getting out of mortgages because the bank didn't actually lend them money.
Ah, yes. The vapor money theory. Or the show me the note defense.
Yeah, that's the one. The idea that banks create money out of thin air so there was no consideration and the contract is void.
This is a classic internet myth. It's very popular in sovereign citizen circles. It stems from a case in Minnesota back in 1968 called First National Bank of Montgomery v. Jerome Daley.
Tell us about Jerome Daly.
So Daley was fighting eviction. He was an attorney representing himself. He argued that when the bank gave him a mortgage, they didn't give him gold or silver, they just typed numbers into a ledger. He argued that the bank created the credit out of nothing, so they gave him nothing of value, and therefore the contract was void.
And what did the judge say?
Well, this is why the myth survives. The justice of the peace, a man named Martin Mahoney, who wasn't a real judge in a court of record, actually agreed with him. He declared the mortgage void and said the bank had committed fraud.
So it worked.
For about 5 minutes in that tiny room. But legally, it was a nullity. The ruling was void on its face. The courts overturned it immediately. Justice Mahoney was actually disbarred later for going rogue. But the story lives on in internet forums. People sell kits claiming they can help you use this defense.
Let me guess. It doesn't end well for the people who buy those kits.
It ends with them losing their house and often getting sanctioned by the court for filing a frivolous lawsuit. Let me be clear. This defense does not work. If you try to tell a judge the money wasn't real, you will lose.
Okay, so that's a dead end. But there are procedural defenses, right? Like the bank just messing up the paperwork.
Oh, yes. And that's where most of the successful challenges happen. It's not about these grand theories. It's about dotting the I's and crossing the T's. For example, there was a New York case where a foreclosure was stopped because the lender's affidavits weren't prepared in the ordinary course of business.
What does that mean?
It means they were robo-signed. Someone was just stamping thousands of documents without actually reading them or verifying the facts. The court said, nope, you can't do that. Go back and do it right. It doesn't kill the foreclosure, but it can delay it for months, even years.
So if these defenses fail, we end up at the auction.
The auction block. This is where the machinery completes its cycle.
Set the scene for us. What's it like?
Typically, it's on the courthouse steps. Or nowadays, sometimes it's online. You have a trustee or a sheriff running it, and you have a crowd of bidders, investors, flippers, bargain hunters. But there is one bidder who has a superpower.
The bank.
The bank. Everyone else in that crowd usually has to show up with cash or cashier's checks. I mean, literally bags of money they have to pay immediately if they win. But the bank can credit bid.
Meaning they bid with the debt I owe them.
Right. They can bid up to the amount of the total debt principal, interest, fees, everything. No cash changes hands. They're just using the IOUs. So if you owe $400,000, they can bid up to $400,000 without putting a dollar down.
Which almost no one else can compete with.
Exactly. And if no one bids higher than the bank,
then the bank wins its own property. That's when the property becomes REO, real estate owned.
right. It goes from being a loan on their books to a physical asset they have to manage and sell.
So when I see a bank-owned listing on Zillow, that's not just a house the bank bought for fun. That's a foreclosure that failed to sell at auction.
Exactly. It's inventory the bank is stuck with. It's a monument to a failed mortgage.
Now, here is where it gets really scary. I lose the house, the bank takes it.
Yeah.
I'm thinking, okay, worst case scenario, I'm homeless, I'm devastated, but at least the debt is gone. I'm starting from zero.
Mm-hmm.
But that's not always true, is it?
No. And this is the sting in the tail. It's called a deficiency judgment.
A deficiency. The difference between what the house sold for and what I owed.
Right. Let's do the math again. Let's say you owed $400,000. The market crashed. The house only sold for $300,000 at auction. There is a $100,000 deficiency. In many states, the bank isn't just going to write that off. They can come after you for that $100,000.
Even though they already took the house.
Yes. They can sue you personally. They can garnish your wages. They can attach your other assets, your car, your savings account. They can pursue you for the principal, the interest, and the attorney fees.
But this depends on the state again, right? It's not universal.
It does. It depends on whether you are in a recourse or non-recourse state.
And California is.
California is interesting. It has a very specific protection, a famous anti-deficiency law. For the original mortgage on your home, what they call the purchase money loan, it is generally non-recourse. If they take the house via non-judicial foreclosure, They can't come after your money. You can walk away.
That's a huge protection.
It is. It's why we saw so many strategic defaults in 2008. People realize, hey, I'm underwater and they can't sue me. Here are the keys. I'm out.
But there's always a but.
There is always a but. That protection usually only applies to the original loan if you refinance that loan, or if you took out a EO home equity line of credit.
The protection disappears.
Often, yes. Those are often recourse loans. So if you refinanced in 2005 to get a lower rate or to pull cash out for a renovation, you might have accidentally converted your loan from non-recourse to recourse.
Oh, wow. So you traded a lower interest rate for personal liability and you probably didn't even know it.
Exactly. And many people discovered this the hard way in 2008. They walked away thinking they were safe, and 2 years later got a lawsuit for $50,000.
And even if the bank forgives the debt, says, okay, fine, we won't sue you for the $100,000, Uncle Sam steps in.
The IRS. This is the final insult. If a debt is forgiven, the IRS often views that as income.
How is losing money income?
The logic is you borrowed $100,000, you didn't pay it back. Therefore, you are $100,000 richer than you should be. That is taxable income. Now, laws have changed back and forth on this, especially around the housing crisis, but the general principle is still there. You lose the house, you lose your equity, and then next April, you get a tax bill for $30,000 on money you never actually saw.
The machinery just keeps grinding. It doesn't care if you're down.
It really does not.
I want to shift gears a bit. We've talked about the legal machinery, but machines chew things up. And in this case, they chew up people. The source material has some heavy statistics on the human toll of this.
It's devastating, and it's not distributed equally. When you look at the demographics of loss, minorities are hit disproportionately hard.
What are the numbers there?
The research shows that African-American buyers are 3.3 times more likely to be in foreclosure than white buyers. Latinos are 2.5 times more likely.
That is a massive disparity. Is that just income levels, or is there something else going on?
It's not just income. It tracks with the history of subprime lending. We know now that banks and mortgage brokers specifically targeted minority communities with predatory inclusion. They sold them riskier, high-interest loans with exploding rates, loans they knew were likely to fail. So when the market turned, those communities were the first to blow up.
But there is another demographic that gets forgotten. Renters.
The invisible victims.
Renters don't own the home. How do they get foreclosed on?
Their landlord gets foreclosed on, and if the landlord defaults, the tenants get evicted. In New York City in 2007, over 60% of foreclosure filings involved rental properties.
60%. So the majority of people losing their homes in NYC weren't the ones who missed the mortgage payment. They were just paying rent to a guy who missed the payment.
Exactly. Collateral damage. You pay your rent on time, you keep the apartment clean, but you still come home to a notice on the door. The bank owns this building now. Get out.
And the psychological impact? The sources mention a study on depression.
Yes, a study of 250 people going through foreclosure found that 36.7% met the criteria for major depression. And what's tragic is that medical conditions are often cited as the cause of the foreclosure in the first place.
Right. You get sick, you can't work, you can't pay the mortgage.
It's a vicious cycle. You get sick, you lose the house. The stress of losing the house makes you sicker. It spirals.
And the credit impact. I mean, we know it's bad. But how bad?
A finalized foreclosure hits your credit score by 85 to 160 points. That's a nuclear bomb on your financial reputation. It stays on your record for 7 years. It affects your ability to rent an apartment, get a car loan, even get a job. Some employers check credit scores.
And here's where it gets really interesting. There is a study here from the Federal Reserve that challenges the narrative a little bit. It's about post-foreclosure migration.
This was a fascinating find. The Fed tracked 37 million people. They wanted to see where people went after they lost their homes. The common assumption was that they would fall off a cliff. They would move to Skid Row or drastically worse neighborhoods.
Right, a total socioeconomic collapse.
But the data didn't show that. It found that while 23% of foreclosed individuals moved within a year, which is a lot, the majority did not end up in substantially less desirable neighborhoods. They didn't move to more crowded conditions.
So they managed to maintain their standard of living without the ownership.
Mostly, yes. Only about 20% went back to a household with a mortgage. Most became renters or moved in with others, but they stayed in similar quality areas. The researchers basically concluded that the shock of foreclosure, while traumatic, might not be as permanently displacing geographically as we feared. People are resilient. They scramble. They find a way to stay in their community.
That's a small silver lining, I guess.
Yeah.
But for the neighborhoods left behind, the spillover effect is real.
Oh, absolutely. When a house sits empty, especially in those judicial states where it takes years, it rots. The sources mention abandoned houses attracting crime, trash, prostitution. It drags down the property value of every neighbor.
So if my neighbor gets foreclosed on, my house is worth less.
Exactly. Your property value declines. And the schools. School mobility is a huge issue. Children forced to switch schools because of foreclosure often move to schools with lower test scores. So the academic future of the child is impacted by the financial failure of the mortgage.
Now, during the 2008 crisis, there was a specific practice that I remember making people furious. Dual tracking.
This was the height of institutional cynicism.
Explain what that was.
Dual tracking is when a bank works with you on one track. Hey, let's negotiate a loan modification. Send us your paperwork. We want to help. While simultaneously, on a second track, pushing the foreclosure process forward.
So you think you're fixing it?
You think you're safe. You're on the phone with a representative who says, we're reviewing your application, everything looks good, and then you come home and find out your house was sold at auction that morning.
That feels like entrapment.
It was incredibly common. Borrowers were blindsided. It got so bad that California eventually passed the Homeowner Bill of Rights on January 1st, 2013, specifically to outlaw this practice. They said you cannot foreclose while a modification application is pending.
But why were banks doing that? Why not just modify the loan? Wouldn't they rather have a paying customer than an empty house?
You would think so, but the data shows otherwise. A 2009 Fed study found that only 3% of seriously delinquent borrowers got a modification.
3%. That's nothing.
The leading theory is redefault risk. The banks calculated that if they modified the loan, lowered your payment, you might just default again in 6 months. They decided it was actually more profitable, or at least safer, to just take the house now and sell it, rather than risk a self-cure that fails later.
It's just cold math.
It is cold math.
All right, we've been very U.S.-centric so far, but this is a global show.
Yeah.
And looking at how other countries handle this, well, it makes you realize the American system is actually kind of unique. Let's start with Spain. Because if you think the U.S. is harsh, look at Spain.
Spain is terrifying. In the U.S., as we said, in many states you can walk away or go bankrupt. In Spain, foreclosure is just the beginning of your troubles.
How so?
Spanish mortgage holders are liable for the full loan plus penalty interest plus fees. And here's the kicker. Mortgage debt is excluded from bankruptcy.
Wait, so you lose the house, you still owe the money, and you can't even declare bankruptcy to clear it?
Correct. You can owe the bank for life, even after they take the house. It effectively creates a class of zombie debtors who can never own anything again, not even a car, because the bank will seize it.
That sounds almost feudal, like indentured servitude.
It has caused massive social unrest in Spain. There have been suicide waves linked to evictions, but the government argues it keeps the banks solvent.
Okay, let's hop over to the UK.
The UK is softer. They don't even really use the word foreclosure much. They call it mortgage possession.
What's the difference?
True foreclosure, where the bank keeps the surplus value, is rare. In the UK, the courts usually grant a possession order. They sell the house. If they sell it for more than the debt, the borrower gets the extra money.
That seems fair. That seems like how it should work.
It is more equitable. The courts are also much more involved in managing the process to avoid total ruin for the borrower.
Yeah.
They try to find a way to let you stay if possible.
Now let's go down under. Australia and New Zealand.
New Zealand is fascinating because foreclosure is actually prohibited by law.
Prohibited. So you can't lose your house.
Well, you can, but not via foreclosure in the technical sense. They use the Torrens title system.
What is that?
It's a land registration system. In New Zealand, the mortgagee, the bank, never holds the fee simple title. They just have a registered charge against it. To get their money, they can force a mortgagee sale, but they can't just foreclose and take the title for themselves. It's a subtle but important legal distinction about who actually owns the land.
It sounds like they are very careful about property rights.
Very.
And finally, China. A place where private property is a relatively new concept anyway.
Right. They moved from granted land rights to allocated rights, which paved the way for private ownership and mortgages. But their system is strict judicial foreclosure.
Right.
Very structured. And in theory, it's supposed to be finalized within 6 months.
Yes.
Sufficient. But again, it's a developing legal framework compared to the centuries of case law in the West.
And there was one more interesting one, Canada, specifically Alberta.
Alberta is unique. They have a process involving the Court of Queen's Bench.
King's Bench now, I suppose.
Yes, King's Bench now. The court takes control of the property first. And here is the twist. The courts favor the owners. They rarely sell under market value.
That sounds good for the owner.
It is, but it has a weird side effect. Because the court insists on a high price and the bank won't sell for less, foreclosed homes in Alberta are often overpriced. They sit on the market forever because no one wants to pay top dollar for a foreclosed home with no warranty.
So the protection actually stagnates the market.
Exactly. Unintended consequences.
Okay, let's bring this home. We've traveled from the acceleration clause in your filing cabinet to the sheriff's auction, through the paradox of the tender rule, and all the way to Spain and China.
It's a lot of machinery.
It is. And for me, the big takeaway is this tension. On one side, you have contract law. You promised to pay. You didn't. We take the collateral. It's binary. It's cold.
Right. And without that coldness, banks wouldn't lend us money. If they couldn't foreclose, mortgage rates would be 20%.
True. But on the other side, you have social reality. People need homes. Communities need stability. Foreclosure is the friction point where those two things grind against each other. It is a cloud on title that becomes a storm for a neighborhood.
And as we saw with the history from strict foreclosure in the 1800s to the power of sale, we are always trying to tweak the machine.
We are. But here is the question I'm left with, the final provocative thought, if you will.
Hit me.
We moved away from strict foreclosure, where the bank just took the land because we wanted to be fairer. We added auctions, we added notices, we added redemption periods, but we also added deficiency judgments. We added credit score destruction. We created a system where you could lose the house and still owe the money.
Right.
So have we actually made the process less punitive? Or have we just made it more bureaucratic? Is the modern foreclosure machine actually kinder than the old one? Or just more efficient at extracting value from the desperate?
That is a haunting question. It makes you wonder if efficiency was the goal all along, not fairness. Well, on that cheery note, I think everyone listening should probably go find their mortgage paperwork tonight.
Check Section 18.
Check Section 18. See if you have an acceleration clause. See if you are in a judicial or non-judicial state. Know the machine you are living inside.
Knowledge is the only real defense. Thanks for diving deep with us today. We'll see you next time.